Thank you, everybody, for attending. I'm just gonna give a little introduction of why we're doing these webinars, and I'll introduce Roy and give a few stragglers a minute to come in here, and we'll get rolling and keep everybody on time. So I'm Brendan. This is Roy. I also have Aaron Ricciazzi on our marketing team, sort of helping me out with moderating. Yeah, thank you. We're back from a little summer break on our webinars, but continuing in with the series. So we decided to do webinars this year to really to be a help to all of you, to all of our clients, and cover topics and things that go beyond just marketing. Because obviously, like, okay, you found us, we got that covered, but we are fielding so many questions and concerns that our clients have about starting a practice, growing a practice, scaling, hiring, finances, and like today, selling and exiting. And we are often involved in these conversations, or our clients are checking in with us. And after being in business for 25 years, we have met so many great folks all around the country that help law firms and are of a similar mindset when it comes to delivering their services and making sure everybody's in good hands. And so that's why we are doing these webinars, to share good knowledge and help good people get connected. And that's a good description of why we have Roy on here today. So Roy and I were just discussing, we've known each other for over 20 years. We met when I lived in Minnesota, and Roy is an attorney. He's a coach to law firms, and but most recently, and in this stage of his career, is a consultant and appraiser and broker of law firms. He's now a nationally recognized expert on this topic, and he's helped dozens of firms get connected and find succession plans. And there's a lot of different ways that this can happen. So I'm really excited to see what Roy has to present. And Roy, I'll let you take it from here.
Thanks, Brendan. Welcome, everyone. Thank you for tuning in. It should come as I'm assuming that a lot of you are approaching retirement or very near there. So I'm going to be, most of the presentation will be geared towards sellers. I do have a few minutes towards the end to talk to buyers and some of the issues that they have. But since I know the majority, or typically I've given a lot of these presentations, are sellers, it should come as no surprise that the billable hour comes up in cartoons about when it's time to retire. You see, here's one example. It just happens one day you wake up and realize that your best billable hours are behind you. Or I got to see the poll here coming up.
Oh, yeah, I've got a poll that you can fill out just to express why you're interested in this.
And then here's another cartoon. Let's see. When billing ceases to be fun, that's when I'm going to retire. I'm assuming there are probably even some younger ones out there. It's not as much fun as it used to be, but you're still practicing. All right, two things you want to accomplish when you sell your practice. And this discussion is really geared towards solos and small firm owners, and usually small firm owners that don't have multiple owners, but still some of the stuff still applies to them. But what you're trying to accomplish, at least in most instances, are two things. Make sure your clients continue to be taken care of, and put a little extra cash in your pocket. Now, as you will soon see, as in this presentation, I do believe firms have value. You can get some extra money. But if you're one of those people who has not saved for retirement, this is not your Hail Mary pass to save the day. There's going to be a chunk of money. You may be able to afford being more generous with the grandkids, take nicer vacations, and do a little addition to the house if you still own a house. But fundamentally, it's not going to change your day-to-day life in retirement in most instances. I always tell lawyers, whether they're 25 or 75, the time to make money is practicing. Yes, the bigger your firm, theoretically, the more value you get, and you could, cash out. But the market, as I will emphasize multiple times in this presentation, is just way too immature to assume anything about the value of a practice and do you have available buyers, et cetera, et cetera. Okay, so the first thing I'm sure most of you are wanting to know is, all right, what's my practice worth? Now, the simplest way to understand, and I give this explanation to lawyers and non-lawyers, is imagine it's Friday. I'm selling my law firm. I decide, I got an estate planning practice. I'm going to sell it to Brendan over the weekend. We execute some sort of transition plan over the weekend. And then on Monday morning, the phone rings. Brendan's answering the phone. He says, "Oh," I call up. Is Roy there? No, I'm sorry. Brendan says, "I bought Roy's firm over the weekend. Can I help you? I've got a lot of experience doing this, this, and this." Then the question becomes, will that client work with Brendan? And there's a two-word answer to that question that you frequently probably give to your own clients when they ask you a tough question. And that answer is, it depends. So my job when I'm at least appraising a firm is to figure out what it depends upon. And that's essentially how I derive what I think a firm is going to be worth. So the ultimate question is there predictable revenue? And that gets into trying to predict the future. And it's above my pay grade to do that with 100% accuracy. What I do when I appraise a law firm, and I'll be very upfront, the best you can do is have a ballpark figure. So I'm up there with Ruth Gehrig, DiMaggio, and Mantle Accountants. I also specialize in ballpark figures. There are people out there who will tell you can pinpoint values, do in this way, that way, that way. I think, quite frankly, they're full of it. They have no understanding of what really goes on in the market and in the marketplace. The best you can do, I believe, is to ballpark. Right. So how do we determine what practice areas have value? And again, it goes back to, is there predictable revenue? Professional goodwill. Okay, that's the concept where, and a lot of people, subscribe to it, that there's nothing to sell because the goodwill is too personal in a law firm. And for many practice, and for certain practice areas, that is definitely true. I think the best examples, at least in most places, is going to be like a criminal lawyer or a family lawyer. So what's going to happen? Let's go back to the Friday to Monday I sell the firm to Brendan, where they pick up the phone and they ask for me and they get Brendan. Let's say I'm a criminal lawyer, someone had, referred, probably gave out my name, and they want me and only me. So they'll go on to the next person in their referral list. Whatever Brendan tells them about, well, I've done this and done that, is usually not going to do any good. So again, so here the goodwill is too personal to have really any value. So what I tell lawyers who basically have this type of practice is, the good news, you probably made a lot of money because you have a lot of professional goodwill. You should have done well. Good job. On the bad news is you really have nothing to sell. But there are some practice areas where there is predictable revenue. And to determine that, you got to go back and analyze, all right, how is the revenue generated? And I've broken it down to three big categories. By the way, everything I am going to be saying in this program this afternoon is pretty much covered in the ebook that was given out in the material. And I also want to add, if you have questions, of course, during the program, I'll take them, but I'm more than happy to answer any questions people have afterward. I'm pretty sure my contact information, my email, by all means, I'm more than happy to answer. Okay, so let's go back to the three categories that typically have value, and it's somewhat relatively easy to explain why they have value. Old files, and the poster child for that. Excuse me, I thought I turned it off. Old files. That's the estate planning. The idea, Brendan wants to buy my firm. Someone's going to call me up on Monday and say, hey, I want to revise, or my parent passed away, I needed to get it probated. There's an assumption that somehow there's going to be future revenue from my old files. Now, the $64,000 question is how much? You don't know how many people are going to call and need the wills revised. They don't know how many people are going to pass. And then you have the other unknown. Will they, some people will work with someone, with Brendan on getting it revised. Others will say, no, I have somebody else I think I'd rather work with. But again, on paper and theory, there's value there. Okay, so that's one category or bucket of predictable revenue. But of course, it's very, very difficult to do that accurately. And that's one of the primary reasons why the best you can do is ballpark figures. And you can't, precisely say, because you can't precisely say how often the phone is going to ring, and then how often will that client even want to work with the new lawyer if the phone doesn't ring. Transferable relationships, since I know I'm talking to small firm lawyers out there, I suspect some of you do a lot of work for small business. In other words, you like, in effect, the GC of a small business that's in your community. There you have a deep relationship. Usually it goes back a long, long time. Then the theory here, the predictable revenue, let's say you have 10 stable clients. So what I would do with Brendan over the weekend is I would work on me introducing Brendan to all my clients, say he's going to do a great job. Obviously, in a succession plan, you're going to have it over a longer period of time than a weekend. But you would have some sort of a plan in place for each client to try to ensure that your clients will work with the new lawyer. So you have 10. What I tell people, the chances of all 10 successfully transferring is probably slim to none. But at the same time, the chance of none of them transferring is slim to none. So it's going to be somewhere, between three and 8 and 9, and who knows. And it's going to be a lot, but a lot's going to be dependent on how well the two parties execute the succession plan for each client, and the introductions, and how well that is managed. And then there's finally what was known as what I call practice goodwill, which is very, very distinct from personal goodwill. Practice goodwill is you want a lawyer from that firm. It's a go-to firm. Let's say it oftentimes would, in a smaller firm setting like here, if you're known as the go-to firm for whatever, estate planning, immigration, high stakes litigation, people, firms, achieve that sort of reputation, and people will call up the law firm, and they're really not that specific about who they work with. And the way I determine if a firm, let's say if I'm working with a small firm owner, whether it's personal goodwill or practice goodwill, is I ask the owner, well, when you get a new client and the new client insists that they work with you, how easy or difficult it is for you to push the work down, to delegate the work. So when you can delegate the work, in my mind, that's the firm that has practice goodwill. If the owner comes back and says, geez, whenever I try that, it never goes well. Well, in my mind, that firm is going to be worth less. How much less? The best you can do is ballpark. You can't go back in time and get a sense of how frequently all that kind of stuff happens. So when a firm does have practice goodwill, essentially what you're selling and what comes with that is basically the contact information. The referral network will come, the phone number, the email address, and the website. It's all packaged up, in one. And the desirability in the marketplace, let's say, I know, obviously, Brendan has an interest in this, and I know tuning in is, what's my website worth? It really is the simple way of analyzing and looking at it, and it makes a lot of sense, is who's the buyer? If you're a new lawyer just getting started, you may have, and your website has 20 years out there and a lot of good content, that's worth a lot of money, to a buyer. Or certainly more attractive to a buyer than if you're the buyer and you're acquiring someone who's smaller. Now, I know there are ways that you can do it on the behind the scenes, and that's why Brendan gets paid the big bucks when there are these transitions. But there are ways to what we call Google juice, or now it's AI juice, or whatever the hell it is, to make sure that the buyer gets the benefit of that. So
yeah, Roy, I'll jump in here and say, yeah, we've worked on a number of creative things over the years, and we've just sort of seen it all. Firms that maybe a partnership breaks up and they want to split their content and still keep things going, or somebody's winding down or exiting a practice area and somebody else wants to come into it, and they buy a piece of things. And we do transferring content or things with the website. So there can be even if it's not the whole practice, there can certainly be chunks of things that get sold that are part of this goodwill package.
Right. And that speaks as much to the point of why it's so hard to get an accurate value. What goes on behind the scenes, no one really knows how effective. You hope it's going to be effective, and it is effective, but how effective, who knows? So All right, let's look at some other factors that impact the value. Legislation, if they ever do anything, let's say with immigration reform or do whatever that's happening, that's going to obviously have an impact. And sometimes you don't even need legislation. Obviously, what's been going on in Trump 2.0 has had a major impact on the immigration practice. And anecdotally, I found it's actually for some it's been good for business, some not so good, and a lot of people in between, which I always find very curious. The economy, the conventional wisdom is, of course, when a recession, bankruptcy, is better. So those kind of law firms will be more valuable. Systems, a lot of people think that, especially when it comes to how they get the work out, their operation, their back office, they think, oh, I got the greatest system, or got the great intake system. They think, that in and of itself is worth X amount of money. I go, in my mind, it'll certainly will make the firm more attractive. The problem is a lot of potential buyers think their own system is good enough. And they not necessarily will pay extra, for your system. So it's really hard to quantify that. I also want to go back to the last slide, talk about websites. Some people will come to me and say, Roy, what's my website worth? It's virtually impossible to isolate that. And there's I guess there is a minimal active marketplace, but it's very, very, can't predict anything about what that's going to be. Typically, the website's going to go along with the practice because it's part of the whole practice goodwill, and it's very difficult to somehow segregate it out. Office space, sometimes I have a selling client who has this premier office space. Needless to say, since the pandemic, what that does to a firm is, it's often, doesn't perhaps add much value. A lot of people have their own office space. A lot of buyers have that situation, figured out. They don't necessarily need your office space, especially post-pandemic. So what I tell my clients, I don't get involved in saying real estate. There are instances where it could make the firm more attractive, and you would get whatever the fair market value is for the office. But if you insist on having, let's say you own the office, then insist that it, become a part of the sale. I can tell you right now, it's going to make it, you're already limiting the number of buyers, because not everyone wants to own real estate. Certainly some, and again, for those people, it will make it more attractive, but certainly it will make it not unattractive to others. Okay, so here's the question that I probably get asked, the most. So what is it worth? What's my law firm worth, Roy? Well, I'm going to make fun of the bean counters because they have their own way of doing it. Here's one way. This is one formula. The excess earning models, a calculation that reflects the amount of the 5-year average of the practice, less the fair return. I mean, you could read it yourself. There's a reason why I became a lawyer and didn't go to business school or, major in finance. In my mind, it's a bunch of gobbledygook and, oftentimes very confusing. And if you know anything about valuing firms, valuing any sort of business, lots of different formulas. And I think the formulas in some respects make sense, but only in a mature marketplace. And the legal is not a mature marketplace. So when I talk about the formulas, many people have heard about formulas referred to as a rule of thumb. So the rule of thumb would be you take 1 times gross, 1 times net, 3 times this, 2 times that, 0.5 this. And people will say, oh, well, a law firm should sell, a lot of people will write, it should be between 0.5 and, 3 of the gross, let's say. But I have my own rule of thumb, and that is there is no rule of thumb. And that is primarily because it's of the immature marketplace. And there's actually a simple explanation to why I think it's a bunch of hooey that you can just say, well, law firms are going to be worth X amount of revenue. Let's say, take, for example, a family law firm that grosses $1 million, a criminal law firm that grosses $1 million, and a personal injury firm that grosses $1 million. If you buy into the rule of thumb and say, all right, law firms, sell for 1.0, then you would value, all those 3 firms similarly. And when you think, and when think about each firm. Each firm gets their clients in a very different way. They charge their clients differently. They have nothing in common. It's like three separate businesses. They have one thing in common. The only thing, and that is they are owned by someone with a JD after their name. So if you believe in the rule of thumb, then you would believe that if a lawyer owns a restaurant, a gas station, and an accounting firm, you're going to value them similarly because they're owned by a lawyer, which of course is nonsensical. Now, could you have a now you can certainly back into a rule of thumb. You can see, all right, I saw, Brendan bought a firm for X amount of money and they did that kind of gross revenue. So at the end of the day, Brendan paid, this kind of, multiple. So that, yeah, that's easy to do. The problem is there aren't enough to really come up with any accurate, multiple. It's not like, most deals, the reality is they're confidential. And it's not like you can look up online and see what the house down the street, sold for. So that's probably the biggest reason why, it's, you don't know what's going on. And it's not unusual for me to hear when I meet a lawyer who actually sold a deal, or and I say, well, how did you come up with the number? Very, very frequently, they basically say, we thought it was fair. In other words, there was no accurate analysis whatsoever, or any sort of sophisticated way to reach it. And at the end of the day, many deals are what seems fair. As vague and that may seem, that's the reality, and it is that way because then again, it's a very immature marketplace. Okay, here's the way I go about going it. So you can call it the Ginsburg method. If you have any more questions, I do the same thing in the ebook. It's a simple way of doing it, and I'll be the first to admit that it's I am ballparking, and there's literally no science to back it up. But I think it is just as valid as any other formulaic way of doing it. Okay, so I'm looking at a firm. Let's say it's a solo, a modest solo firm. The annual gross revenue was $500K. So I'm going to assume, if you go back to what I talked about, does a firm have value? Is there going to be predictable revenue? Okay, I'm going to assume, well, in year one, the phone's going to ring, a little, but not as much as it did when I was there. Some people are going to say no to Brendan after I sell the firm. And that number will likely go down. Now, is there any science to back that up? No. But I think it's logical and it makes sense that somehow the annual gross that's attributable to me. Now, I'm not saying Brendan, when he takes over the firm, is, he has his own business. He can generate his own revenue. But people from my old estate planning files, I'm going to predict that over the 4 years, there's going to be $1 million by that and so there are a few things that are somewhat arbitrary and just guesstimates. Number one, how much I decrease the revenue. Number two, I say I think it's reasonable for a buyer to purchase revenue for 4 years. In other words, by the time 4 years have gone by, that phone's not going to ring at all because of me. All those files. Now, people can argue, no, the phone's going to be ringing for 6 or 7 years. People could argue, no, Roy's way overestimating. It's basically going to stop ringing after the second year. There's no real predictable revenue. So reasonable people could differ about these numbers, but I think the concept, it's hard to, at least in my opinion, argue with. So I'm going to assume that over 4 years, I'm essentially selling to Brendan $1 million of business. So then the question becomes for Brendan, all right, it looks like if I buy Roy's practice, I'm going to get $1 million of additional revenue over the next 4 years. What am I willing to pay for that? And what I do is I make it seem like it's a referral fee. Lawyers understand referral fees. Now, of course, there is no referral fee being done here. It's just a way that I use as a concept to make it easy for lawyers to grasp, and anybody else for that matter to grasp. So I say, all right, so Brendan should be willing to pay me at least 15% of that money. So my firm is worth maybe 150K, or maybe it's worth 20%. I want 20, and where that percentage is, reasonable people could differ on that. You rarely would say seek more than 25%, because if I ask for more than 25%, that new client from Brendan would not be profitable at all. whatever profit margin was there. So, and I am well aware that in the personal injury world, it's a third of a third, but as a practical matter, if you insist on getting $333,000 for the $1 million of revenue, the owner's not going to make it, will make very little, or in fact may lose money on my clients. So no smart lawyer would agree to those figures. But I want to emphasize, this is why I go back to the best you can do is ballpark, because you're making a lot of assumptions. They sound on its face reasonable. They do make sense, but there are a lot of ways you could, you can certainly argue that some of, like I said, that the length of time is too much or too little. The percentages are off. But, I like this because it's something that you can at least get your hands around. Because essentially, when you're buying a practice, you are buying revenue. As I'll explain a little later on the why buy. You could try to buy the marketing services for your practice and then build it that way. So you pay the modern firm X amount of money and you hope you get revenue. Well, an alternative way, or you may want to do it combined, is you find a practice to buy. It's going to cost you money. So instead of spending X amount of money for the modern firm, you spend X amount of money by buying a firm. It's just an alternative, to achieve more, achieve revenue growth is what it boils down to. Okay, now there are a lot of there's what I call 3 different methods that sellers, especially those approaching retirement, in this day and age, that's usually when those are the only firm owners looking to sell. There's the hire to retire. There's where you basically hire someone who eventually is going to buy you out. I'll discuss all 3 of these in more detail with a few more slides for each. There's a buyout. That's internally. Usually you have an associate or a not-equity partner buy you out, or sometimes you have 2 equity partners and one equity partner is going to buy out the other equity partner. Or you do a third-party deal. And there are different ways to label them: a sale, of counsel, or merger. It's essentially the challenge is finding the third party, and depending on how long the seller wants to hang around, that's usually dependent. That usually determines how you're going to label that method. So let's talk about the hire retire. Typically, the notion is you hire someone, more often than not, it's a newbie. It takes about 3 to 5 years. You train that person in the first couple of years, and then they buy you out. A lot of people try it. When I have prospects call me, I always ask them, why are you calling me now? Usually a few times a year, someone will say, well, I thought I had a successor, but that person left me. No surprise, because the strategy is incredibly flawed. And if lawyers, just sat back and at least thought about it a little more thoughtfully and carefully, they would realize that it's destined to fail in 95% of the situations. You got to be luckier than all hell for it to work. Here are all the flaws. First of all, it's not so easy to find a successor. As I'm sure a lot of you tuning in, it's hard enough to find anybody these days, whether it's staff, an associate, and to add that extra qualification. Is this person going to be able to run this law firm? You're asking way too much. You're never going to find that, or it's going to be really hard to find that person. It's really hard to find someone with enough experience. Do you want to spend the last few years of your career training and mentoring someone? A lot of lawyers, that's the last thing they want to do. Here's where the economics make no sense when you think about it. You're a solo who grosses $500,000 a year. Let's say you comfortably take home 200 of that 500, and your expenses were 300. Now you hire this new associate, and this associate typically won't have a book of business, and you got to pay that person something. So let's say you decide to pay that $75K. Where's that $75K coming from? You don't necessarily have extra business. It's going to come right out of your pocket. So essentially what you do when you do the hire to retire strategy, you're subsidizing your own retirement. Assuming the person will be willing to buy you out, you've already given up extra money already by executing this strategy. And then, of course, the final death knell is they can always turn around, stab you in the back, and leave, which they do. So again, if there's one takeaway from this that I want everyone to do, don't even think about doing it. When you hear anecdotes of have this work for so and so, it worked for so-and-so usually because they hired that associate 10, 15 years ago. They have a long working relationship. And when they hired the associate, no one ever thought of successorship. It just worked out that way. And that happens. But to do it at the tail end of your career or is just a foolish strategy.
Roy, I
Now,
had a question from the audience
sure.
related to this. So, and just answer when it seems appropriate. So, it was, do you have a suggestion for how to handle associate or non-equity partner buyouts, assuming a high cost of living area, lots of law school debt, et cetera? How does an associate come up with the dollars for a large buyout amount?
All right, that's perfect question because that's what the slide is going to address. And if I don't address it, send me an email. Okay, basically you do it. Well, just like that situation that Brendan just read. It rewards loyalty. Now, I can't overemphasize. There's no magic number of what the firm is going to be worth. I always tell clients, because a lot of my business are people just like that scenario. Partner calls me up. I want to sell it to somebody. I need you to appraise it. So I'll appraise it. And in my report, I always tell them that my report is a starting point. It will rarely be an ending point to what the deal is for two practical considerations. What they can afford. Do they have a student debt? And so at a certain level, they got to factor it in. So you make it easy. If I may say the firm is worth $500,000, but if there's no way that the associate can afford it, what's the point? Then you got to say, all right, am I going to get $500,000 from somebody else, or should I accept less from the inside? Tough question. No easy answer to that. But so the one practical consideration is how much they have in the bank, or could they get an SBA loan? Are they willing to even take out a loan? And then two, what are their employment alternatives? If the price is too high, some of them will just say, hey, I can start my own firm. Yeah, the first few years are going to be lean, but I'd rather be lean the first few years than, paying off a debt for the next 10 years. And lower my standard of living. So those are the two major practical considerations that will frequently impact exactly what the associate or non-equity partner will pay. If you are a seller, you will have to open your books. They are buying your business, and so they're going to they'll see how much money you made on their sweat over the years. And I always advise my clients, it should always be considered. I'm not necessarily thinking it should be done all the time, but it's better the devil you know than the devil you don't with a third-party sale. You know what you're getting yourself into. You know the buyers, their strengths and their weaknesses because they work with you for a while. And again, what I always emphasize, not only is it considerate, but it's better than you can think. A lot of my clients will say, Roy, so-and-so is not a good idea, good. And they say they're not as good as me. They don't do this as well, blah, 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 blah. Well, no, if that's your standard, no one is going to be as good as you. One of my favorite quotes more recently is don't let perfect be the enemy of good. But again, I always prefer it more controllable and predictable. You maintain the brand usually when you do when it's a buyout. When the third party buyer, who knows what's going to happen to the brand. And again, just as important, sometimes third party buyers are not as easy as you think it is. So let's talk about a third party sale. Okay, because we talked about the hire to retire. Don't even think about it. You can do internal deals. But I know some of you may be solo, or for whatever reason, there's no way there's no way that you can be able to do an internal deal. So you will have to turn to a third party. I consider third party sales, and as the idea where the seller is basically going to just hang around enough to transition the practice, make sure everything is going fine. In other words, you're not going to be doing any legal work of any substance. You're there just to make sure the transition goes smoothly. Depending on the practice area, that can be it can be weeks or a few months. It doesn't necessarily have to be a long period of time. Other practice areas, it may take more time than that. But the concept, at least in my mind, when I label something a sale, is where when the owner rides off into retirement sunset, he's done. He or she is done. And there are a couple of ways you do those deals. You say, all right, I want, X amount of money. I want $500,000. And hopefully you tell the person, to get it, take a loan. And I want it all at closing. Or the more likely way is it's going to be somewhat contingent on the future performance of the law firm. And then what's known there is commonly referred to as an earnout. So in other words, you'll pay a percentage of the future revenue over time. So in other words, I'm more than happy to do a deal, but I'm only going to pay for it unless I know the phone rings and the clients are going to work with me. But you want to get a down payment. So let's say if you want $500,000, you say, all right, I want 100,000 down or 200,000 down. You got to have skin in the game for a buyer. And if you're a potential seller out there listening, and you're hoping that someone's just going to write you a big fat check, it's very, very, very unlikely. Lawyers just don't have that risk DNA to do that. It's not like other more mature industries where people do that all the time. They just don't do it in law. There are a few rules when you do the sale. There's a rule in pretty much every state with 1.17. And the rules are not that complicated. You can see it right there. You got to sell the whole thing or a portion. Some states require you to sell the entire. You can't break it off. You're not supposed to raise fees for the first year after the sale, and you got to give notice to the clients. These are all things that you would probably want to do in any event. So it's not that, it's a somewhat of an administrative hassle, but not much at all in the scheme of things. The hardest thing, quite frankly, is finding that buyer. Is not as easy. There are other rules surrounding selling. You got to make sure you sell to someone who knows what they're doing. You have confidentiality issues and conflicts. The conventional wisdom is, it's just no different than, let's say, if you're in a bigger firm and you're lateraling over to somewhere else, you provide lists and things like that. If you want to get into the file, you got to get the consent of the file, because remember, the file is owned, by the client. Okay, another way to do the third-party sale is the of counsel. A lot of people, I'm sure, know of or heard of a way where they see or hear of somebody joining another firm and becoming of counsel at that place. And there's no place in the rules that defines of counsel. It's I think the best you can do is an ABA opinion and on it. And it was years ago. Basically, you got to have a bona fide relationship with the law firm. And the deal, this transaction, is going to be essentially, how am I going to be paid if I go join this new firm? This is frequently done where the lawyer wants to work for a few more years or slow down and doesn't mind doing legal work. So you want to make sure the deal is you get paid. What most law firms have, what's known as origination policies. You get paid, a piece of the revenue that comes in. So what is that number? Usually could be as little as 5%. It could be as much as 20, 25%. So every dollar that comes in, if the client is yours, you get paid that. Then, of course, if you do extra legal work, you want to get paid for that. Now, the real value of the firm, though, if you do enough counsel arrangement, is you want to get paid for what I call trailing revenue. When you're really not doing any billable time, you're just coming in, having lunch, a few times a month with the partners. So you're still on the website. You want to be able to get paid the origination for 1, 2, 3, 4, 5 years. That's essentially what your law firm sold for. Because while you join the firm as of counsel and you're just working for somebody else. And oftentimes you have less money than you made on your own. But a lot of people will do that as a deal. The advantages, you don't have to manage the firm anymore. Old files, especially some of the old timers, you don't have to worry about what happens to them. They usually retain custody. Sometimes staff is retained and you don't have to deal with any Rule 1.17 issues. Disadvantages, you're not your own boss anymore. That's a big, big adjustment for a lot of lawyers. Culture is not the same. You're probably going to make less. Why will you make less? Their overhead. First of all, 100% of the profits are going to you now as a sole owner. No one's going to want to do a deal with you unless they get a piece of those profits. So by definition, there are less profits to go around for you. and typically their overhead will be higher than yours. There are rare occasions where you'll make more, and that's only if you're referring out a lot of business that you can now refer into this particular law firm. That rarely happens, and sometimes there are rate issues. This is especially an issue if you're a suburban lawyer and you do a deal with a downtown firm, that your clients, if you're the suburban lawyers, may not want to pay. That could actually be a deal breaker, because the firm downtown, they want to book, but they know the clients are going to leave because the downtown rates are too high. It won't happen. Or that makes it, if they do happen, it makes it less likely that when the phone rings on Monday, they'll agree to work when they hear, what the rate would be. I guess if it's again, you could probably get around the Rule 117 about raising the fees. I guess it really depends. That could be a problem. But in any event, they're going to want to raise it certainly after a year. All right, who are you going to sell to? Usually the best buyers are going to be friendly competitors. One of the things, when I got into this business, I figured, well, I'm calling and doing this in the Twin Cities. I thought, well, I know a lot of people in Minnesota. A lot of people in Minnesota know me. I can do it in Minnesota. That'll be pretty easy. But the reality is most of the buyers, have people in mind. They're friendly competitors. They already know who has a good reputation, who they can trust, who's competent. And they're frequently the first tier if there is no option for the insiders. Firms also within friendly competitors, they may not be seeking to enhance the practice or expanding into a new one. And the whole new thing, is private equity. Some of you may have heard. This is especially popular now in personal injury. It is not turning the world upside down yet. As far as buying and selling, there would be an understatement to say there are a lot of unanswered questions. Some of you may be familiar that, accounting firms, dentists, doctors have had a private equity in a big way enter it. And they have rules very similar to legal about how the professional judgment is not to be interfered with by private equity. So they've been doing it for 10, 15, 20 years. So that same model, people now with a lot of money looking to disrupt something else, or looking to disrupt legal, just like they have already disrupted other professions. There is a workaround. The simplest way to describe it is you have two entities. You have what is known as a managed service organization, or an MSO. Think of it as your back office, and it does everything, including hiring your staff. In other words, the staff works for the back office, and they do anything and everything that normally you would do as a firm. And then it's a separate organization known as the law firm, and that is staffed by the lawyers. Now, how they work, and then essentially the law firm, they bill the law firm for their practice, for their back offices. So that's how the private equity people make money. Now, how separate that wall is, on paper they're very separate. In reality, no one really knows how it's going to work. I tell people, and this has just got a lot of buzz for it now for about a year. I never knew what an MSO was till a couple of years ago. And I've been doing this kind of work for 15 years, to give you an idea. And now that's all people are talking about it. But it is, quite frankly, a lot of talk. And there are deals being done. It's primarily in personal injury firms, and it's primarily not as an exit strategy. It's primarily personal injury firms just seeking capital to expand. Everyone thinks AI is going to, increase the costs of doing business. That's too early to tell how much that will do. So that's why there's a lot happening. So you may be reading about it. As a practical matter, depending on the practice area, theoretically it increases the number of buyers, but they're only interested in practices where they could further enhance marketing and operations. That's where they think they could do the best bang for the buck. So in other words, one of the reasons personal injury is so popular is they have they're going to streamline ways of getting new clients. They're going to decrease the acquisition costs of new clients. They're going to be able to get from A to settlement a lot faster and more efficiently than the current lawyers. So that's a practice area that's the private equity wants to buy into. Immigration, very paper intensive. Estate planning, same thing, intensive. So it's only ones where there's a lot of personal goodwill or multiple owners. It probably has no place in it.
Roy, I got another question related to that from the audience. It was, do either of you have access to individuals or firms who are looking to purchase firms such as, this person's? I'll answer first, which is to say that um, we sometimes catch wind, of clients that are looking to wind down and can occasionally connect the dots. Like, oh, I'm looking to either get out of this particular practice area, or I'm, want to shut down. And we can sort of aid. Oftentimes, we're aiding maybe on like the technical side of things if we have another client in the area who does a similar thing, and that's probably happened a half dozen times, over the years where we've helped. More with like the transfer of like marketing systems and digital assets. But yeah, usually then when we get asked, I will often, shoot an email after you, Roy. But I don't know, do you sort of ever have a list of people who are like, yeah, I'm always
Yeah.
looking to buy?
Oh, yeah, yeah. I mean, I tell the story. The first time anyone ever called me, say, "Boy, who are you working with? I'm interested in buying a law firm." It's 5 years ago. The second time was 4 years ago.
Mhm.
Now I get it, once or twice a week. From oftentimes, 90% of private equity kind of folks. A lot of them don't know what the hell they're doing. They're just following the latest fad. Some are very sophisticated investors and fully know what they're getting themselves into. Most are in between. But so it's not surprising now that I get contacted. But what is relatively new is they're directly contacting the clients. I've had clients who retain me to help them figure out who to sell to, and while we're working together, they will be directly contacted by a private equity outfit saying if they want to buy. I mean, with AI, it's pretty easy to find who are the law firms that are owned by people, 65, 70. So they're very, very aggressive. They become very, very aggressive. But again, it's only certain practice areas that they tend to be going after. So yes, I have a list of buyers, but in many ways, it's like Brendan. There's so many different, the geography, the practice area, that it's not as easy as it looks to make a match. On paper, it looks like it should be easy. You got a lot of retiring people. People are hungry to create business, but as a practical matter, not so easy. So how do you find someone? You hire people, someone like me. There are a handful out there. You can hire a business broker. They oftentimes they occasionally know what they're doing if they have done other law firm deals. Most of them have not. I would personally stay away from a broker unless they understand the legal marketplace. And you can do it yourself. I'll be the first to tell you, that people, when they, hire me and they pay me to do the work, they can certainly network and advertise. The problem there is the confidentiality is lost. So a lot of people will hire someone such as myself because they want to preserve the confidentiality of a deal. They don't want the staff to flee what they hear they're going to sell. Or lose out to a competitor. And again, I want to emphasize why deals are not so easy to do. Buyers tend to have what I call the three don'ts. They don't have money. Again, a lot of student debt, things like that. They don't have a risk appetite. And with all due respect, most don't have much business acumen. So I say they wouldn't know a good deal if I hit them over the head. I always say and give this presentation to 10 potential younger lawyers thinking about buying. And the light bulb will go off in one or two. Lawyers just don't think that way as business people. The common question I get asked: what should I do to prepare my law firm for sale? They sometimes call me 10 years out. I said, my advice is what President Obama had for his theory of diplomacy when people asked him what it was, and it was don't do stupid shit. What's stupid? That signing a 10-year lease when you're 75. Yes, I know a lot of people write that you should systemize this, clean up your financial records. There's a laundry list of at least a half a dozen, probably even a lot longer things to do. I've always maintained that those people have been thinking about doing them for the last dozen years and never get around to it. And I don't think they're going to necessarily get around to it now. So I'm somewhat a realist on when it comes to that. why buy? If you're one of the younger lawyers tuning in here, or maybe not so young, it's another way to grow and earn out. If you're not paying a fixed amount, minimizes the risk. So it's really not all that risky as it may sound. And for some lawyers, if you do a deal, you can get a mentor. I know a lot of people want to buy, hoping to get a mentor in the process. And then finding sellers, the way you do it is similar to find buyers. You can network, target, consultants, or people will call me, especially. But I rarely ever got that call from a young lawyer. Like I say, I get the call now from private equity folks. So if you're thinking, some of the ones tuning in here, I tell people a common question: when should I start thinking about this? Some people are out there writing, 5 years. I think that's way. If you're going to do a third part, if you're going to do an internal deal, you probably should be thinking about it 5 to 7 years out to give you a long runway, because a lot of things, may go wrong. You want to have time to readjust, and you want to get the insider to start feeling like an owner. And have that title, even though you would not necessarily give up complete control. But if you're going to do a third-party deal, I think 2 to 3 years out, because if you find somebody, you may not be ready to. If you go out 5, 7 years and you're really not ready to go part-time or slow down, then what? What are you going to do? It's way premature. So I tell people, contact me between 2 and 3 years, depending on how much when you want to slow down will be the time. To plan. And when you do that, do it when the sun is shining. Don't do it. There are 2 reasons why people call me the most. One is a health condition that you don't want to wait till then. Then sometimes it could be a fire sale, or 2, when the lease is up. I mean, I get a lot of those. And I just tell people, when you at a when you're, going to a happy hour with other retirees, is that dictating the timing? I would think there'd be other factors involved. Certainly, it's an important factor, but it shouldn't be driving the bus itself. All right, I see I got 5-10 minutes left. People have questions. If you have questions, Brendan, or anything like that, how you want to handle the end?
Yeah, sure. So we have a question feature here where you can submit down at the bottom if there's any additional questions. There is one pending here, which was, Roy, when working with you, how do you charge for services? How does that work?
The simplest form, I have a fixed fee up front, basically to appraise and get an idea of what you want to do and what's going to be a perfect exit, and assess who the potential buyers are going to be for your practice. And then if you want my help to help broker it, that would be subject to a second fee, which would be more or less a brokering fee that a lot of people, may be familiar with. It's basically contingent upon a sale. Occasionally I'll work purely contingent. It's rare, because I spend time and money getting a law firm prepared for sale, and getting to know the owner's objectives and things like that. And I know this, given that especially if in more rural areas, sometimes you can't find, when I'm working with a rural client, there's no guarantee I'm going to find a buyer. As many people may know, no one wants to work there or live there, at least like they used to. So I got to get paid back some. It's a modest amount, and some brokerage fees will charge a retainer. It's not unheard of. So my business model is more like that. It's rare, but it does happen. If I think the firm is going to be easy to sell, then I will do a pure contingent.
Sure. Another question here, which I think we can both chip in on, is: do you have any suggestions or referrals on advisors to both grow and prepare the practice for a future sale? And so I'll say we see this a lot in conversations where we have clients engaging like with our marketing services that want to ramp things up to get the practice being more profitable. So certainly, like, an aspect of growing is the marketing side of things, whether it's digital or more traditional methods. But then, Roy, I know you've been involved with a lot of like business coaching as well. There's a whole other side to it, right? Like you can't just suddenly get 100% more business and not change and adapt your systems and the way that you work.
Yeah, so you gotta do something. I mean, like I said, Brendan's right. There's traditional, there are certainly a lot of ways digitally, to do that. There's the old-fashioned networking. It's really so dependent on the practice area, and of course you can buy a firm if you want to grow the firm. So in theory, if you're thinking about selling your firm and you want to grow it to sell it, it's not crazy if you're 10 years out to buy a firm, to order to accomplish that. I do some business coaching. It's what I tell people is from 40,000 feet. I'm basically will, get an idea of what, where your firm is at. Where do you think there's areas? And, we may decide digital marketing, but I'm not going to be the one doing the digital marketing advice. I will say, hey, why don't you give Brendan a call? He's got some good people who can help you with that. Or I suggest they join organizations or do, what kind of networking. Some practice areas, old-fashioned networking, I still believe is going to be the most efficient. Not every practice area is going to necessarily do better with certain marketing techniques. Don't get me wrong. Everyone needs a good website because for a lot of practice areas, just for validation. But only certain practice areas will really, a lot of digital marketing be helpful for. So it's really going to depend on the practice area. So practice area specific.
Sure. And I'll close this question out by saying, this was asked by David. We're also going to have in the coming months, we unfortunately had to reschedule for our next one, but we have a consultant coming in who is a implementer for EOS, which is called the Entrepreneurial Operating System. And it is one of several ways of thinking about entrepreneurial businesses to help you scale. And it's something we run on that system. But it does help a lot with the issues that come up as a business grows with just hiring, accountability, getting people doing the right thing, having systems and processes that you really have a lot of control over, so that you just don't keep on bumping up against, the ceiling, as you grow. So it is the operations and running the practice all go hand in hand with, the marketing that grows it, and they both have to sort of be happening in coordination.
Yeah, I want to add in a little to what Brendan just said. I think it's a great idea, whether it's with this system or anybody else. You learn a lot when you meet other business owners in other areas. They don't so don't poo-poo it. Whenever I work with someone, or let's say someone, occasionally I'll have a seller and they have done a system. In fact, I know, one of my clients does that EOS thing. And I'm always impressed because those are the owners who are ahead of the curve, and they tend to be, I don't think it's by accident, they tend to be the most successful. When they look at it, I always say the people who are most successful, especially a lot of Brendan's clients, and I'm sure you'll agree with me, Brendan, is the ones who think of themselves first as a small business owner and second as a lawyer. Those are the ones who win in the marketplace. If you think of yourself as a lawyer first, and oh, by the way, I own a business while I'm doing it, you'll do fine, mind you, but you're not going to be as successful as some of your competitors.
Right. Yeah. Yeah. Absolutely. Last question I have pending here is: do you offer any sort of free consultation or introductory call?
No. Do I charge for any? No. Anyone calls, no charge for any. To learn more about my business. No
Yeah.
charge at all. Be
Yeah.
happy to talk to you.
Sure. And you'll find Roy has a wonderful website by The Modern Firm. So you can find a lot of information about him and get things scheduled there.
Yeah. I've had a website. My first website was with Brendan about 20 years ago. And I've probably redone it, I don't know, 5 or 6 times. And not only do I now have 3 websites with Brendan, because I have, in some ways, 3 businesses. I have the coaching, which I don't do that much of anymore, but still do. I do strategic planning. That has its own separate website. But most, as Brendan said, most of it is the sellyourlawpractice.com. And that's been around now for over a decade. So Brendan, Brendan gets a lot of those monthly fees from me, just like a lot of you. But I get multiplied by 3 times.
Well, we are at time. Roy, awesome. Thanks for bringing us in right on the minute here. Everybody still attending, thank you for listening. We will be in touch with invites throughout the fall. We have some topics coming up on the things we were just mentioning, on business development and systems, as well as like IT security and a lot of the frauds and scams going on out there right now to get you all educated and being aware of what's happening. So thank you all for attending. You'll receive an email after this. I don't know exactly. It's not automated. It'll be coming after this with a recording, and you'll also have a copy of Roy's ebook in a PDF for you to view as well. So enjoy that. And again, thank you all for attending.
Yeah, I want to thank you too.